In copyright infringement cases, copyright owners must generally prove ownership of a valid copyright and unauthorized exercise of one of their exclusive rights from the Copyright Act. Correspondingly, one affirmative defense to copyright infringement is that the alleged infringer had a license or consent from the copyright owner. The Ninth Circuit considered whether an alleged infringer had an implied license for computer programs in Asset Marketing Systems versus Gagnon. For several years, Kevin Gagnon worked as an independent contractor for Asset Marketing Systems, or AMS, helping to meet the company's information technology needs. During that time, Gagnon developed 6 custom computer programs for AMS. Gagnon installed those programs on AMS computers and stored the source code on-site at AMS, in a room that was accessible by a few key employees. Over the course of their business relationship, AMS paid Gagnon over $2 million for his work. In May of 2000, the parties entered a year-long Technical Services Agreement, or TSA. The TSA outlined Gagnon's fees and his planned services for AMS, but said nothing about licensing. Subsequently, in June of 2003, Gagnon submitted an Outside Vendor Agreement, or OVA. The OVA provided that Gagnon would retain copyright ownership over any custom computer programs developed for AMS, but AMS would have a non-exclusive, unlimited license for the programs. AMS decided not to sign the OVA, and their business relationship ended shortly after that, though not without hostility. Gagnon sued AMS for copyright infringement, claiming that AMS infringed his copyright in the 6 custom computer programs by continuing to use and modify the programs without his consent. The district court entered summary judgment for AMS, finding that it had an implied, non-exclusive license for the programs without any limitations. Gagnon appealed to the Ninth Circuit.